Home Affairs Minister Leon Schreiber has made substantial progress in addressing the Zimbabwe exemption permit situation, a development that holds significant implications for nearly 176,000 Zimbabwean nationals living in South Africa. On the 6th of August, 2024, Minister Schreiber signed and published Immigration Circular No. 7 of 2024, a move that aims to streamline the visa application process for ZEP holders and reduce the bureaucratic barriers that have long burdened them. This action represents a critical step in resolving a situation that has been fraught with uncertainty and legal challenges for years. The Zimbabwe Exemption Permit (ZEP) program has its origins in the Dispensation of Zimbabweans Project (DZP), initiated in 2009. This program was initially conceived to provide legal status to Zimbabweans who had fled to South Africa due to the dire economic and political conditions in their home country. Over the years, the program evolved, first into the Zimbabwe Special Permit (ZSP) in 2014 and later into the ZEP in 2017. Each iteration of the program aimed to offer temporary relief, but the absence of a long-term solution led to ongoing uncertainty for permit holders. The Department of Home Affairs' decision in November 2021 not to extend the ZEPs exacerbated the situation, causing widespread concern among the permit holders, many of whom scrambled to find alternative visa options amidst a backlog of applications. The situation became even more complicated due to the legal battles that ensued. One of the most significant developments in this regard was the involvement of the Helen Suzman Foundation, a key advocacy group that has tirelessly fought for the rights of ZEP holders. The Foundation's efforts culminated in a landmark Constitutional Court judgment on the 18th of June, 2024, which dismissed the then Home Affairs Minister Aaron Motsoalidi's application for special leave to appeal. This judgment was a pivotal moment, ensuring that the rights of ZEP holders were upheld and that they would receive fair administrative justice. Minister Schreiber's appointment brought a renewed focus on resolving these issues. His decision to sign Immigration Circular No. 7 of 2024 has introduced several critical changes, particularly in the application process for general work visas. One of the most notable measures is the waiver of the Department of Employment and Labour recommendation and the South African Qualification Authority (SAQA) evaluation requirements for ZEP holders. These requirements, which are typically mandatory for general work visa applications, have often been cited as significant hurdles for ZEP holders. By waiving these requirements, the minister has effectively eased the transition of ZEP holders into the mainstream visa system, reducing the administrative burden and potentially speeding up the processing of their applications. The impact of these changes extends beyond the individual ZEP holders. Employers and businesses in South Africa, many of whom have invested significantly in their Zimbabwean employees, have faced considerable challenges due to the legal uncertainties surrounding the ZEP. The streamlined process introduced by Minister Schreiber is expected to provide much-needed stability and clarity, benefiting both employees and employers. This is not just a humanitarian gesture but also an economically sound decision, as it allows skilled workers to continue contributing to the South African economy without the constant threat of deportation or legal difficulties. The history of the ZEP program is marked by various phases, each fraught with its own set of challenges. The initial DZP program in 2009 was a response to the influx of Zimbabweans fleeing their country's turmoil. It allowed those with clean criminal records and evidence of employment in South Africa to regularize their status temporarily. This was followed by the ZSP in 2014 and the ZEP in 2017, each aimed at providing temporary relief. However, the lack of a permanent solution led to an atmosphere of uncertainty, legal battles, and a sense of impermanence among ZEP holders. The introduction of Immigration Circular No. 7 of 2024 by Minister Schreiber represents a significant shift towards resolving these issues, offering a more stable and predictable framework for ZEP holders moving forward. The response to Minister Schreiber's actions has been overwhelmingly positive, particularly from immigration experts and advocacy groups. For instance, Claudia Pizzocri, CEO of Eisenberg and Associates, a leading immigration and citizenship law firm, has praised the minister's decision, highlighting the positive impact it will have on the lives of ZEP holders and their families. The circular also addresses the needs of dependent family members, such as foreign spouses and children, who are legally residing in South Africa on visitor or study visas. By providing a clear pathway for these individuals to regularize their status, the circular helps ensure that families can stay together and continue their lives in South Africa without the looming threat of separation or deportation. The broader implications of these changes are profound. By reducing the administrative burden and streamlining the visa application process, Minister Schreiber is helping to create a more efficient and responsive immigration system. This is expected to have positive effects on South Africa's economy, as it allows skilled workers to remain in the country and contribute to its growth. Furthermore, it sends a strong signal to the international community that South Africa is committed to fair and humane immigration policies, aligning with global standards of justice and human rights. Another significant development within the Department of Home Affairs has been the shift towards digital processing of ZEP waiver applications, an initiative that has seen over 60,000 applications processed. This move represents a major advancement in the department's operations, significantly enhancing efficiency and reducing opportunities for corruption. The shift to digital processing, which was officially implemented in early 2024 after a series of pilot programs and consultations with various stakeholders, marks a new era in how the department handles immigration matters. The digital processing system was designed to streamline the application process, making it more accessible and transparent for applicants. Prior to this, the process was often criticized for being cumbersome, slow, and prone to corrupt practices. Applicants had to deal with a complex web of paperwork, in-person visits, and lengthy waiting periods, all of which contributed to delays and frustration. The introduction of digital processing has addressed many of these issues, allowing for faster and more efficient handling of applications. Minister Schreiber has been a strong advocate for modernizing the department's operations, and the digital processing initiative reflects his commitment to improving service delivery and combating corruption. Since his appointment in July 2024, he has prioritized the implementation of digital solutions, a strategy that has been supported by a dedicated team within the Department of Home Affairs. This team, comprising IT specialists, policy advisors, and frontline staff, has worked diligently to ensure the successful rollout of the digital processing system. The impact of this digital transformation has been significant. By processing over 60,000 ZEP waiver applications digitally, the department has been able to drastically reduce the backlog that had accumulated over the years. This has provided much-needed relief to ZEP holders who have been living in a state of prolonged uncertainty. The digital system has also enabled the department to send outcomes to applicants electronically, further speeding up the process and ensuring that applicants receive timely updates on their application status. Another critical advantage of the digital processing system is its role in reducing corruption within the Department of Home Affairs. In the past, the manual processing of applications created numerous opportunities for corrupt practices, as applicants often had to rely on intermediaries or pay bribes to expedite their applications. The digital system has significantly diminished these opportunities by providing a more transparent and accountable process. Applications are now tracked electronically, and applicants can monitor the progress of their applications online, reducing the need for in-person visits and interactions with officials. The success of the digital processing initiative can be attributed to several factors. Firstly, the department invested in robust IT infrastructure and software solutions to support the digital system. This included the development of a secure online portal where applicants can submit their applications, upload supporting documents, and receive updates on their application status. The portal is designed to be user-friendly and accessible, with clear instructions and guidelines to assist applicants throughout the process. Secondly, the department conducted extensive training for its staff to ensure they were equipped to handle the new digital system. This training covered the use of the software, data security protocols, and customer service skills to assist applicants who may need help navigating the online portal. The department also established a dedicated helpline and support center to provide assistance to applicants and address any technical issues that may arise. The digital processing of ZEP waiver applications has also been supported by various stakeholders, including immigration advocacy groups and technology partners. Organizations such as the Helen Suzman Foundation have played a crucial role in advocating for the rights of ZEP holders and supporting the transition to digital processing. Technology partners have provided the necessary expertise and resources to develop and maintain the digital system, ensuring it operates smoothly and efficiently. The broader implications of the digital processing initiative are significant. By enhancing efficiency and reducing corruption, the Department of Home Affairs is setting a positive example for other government departments and agencies. The success of this initiative demonstrates the potential of digital solutions to improve service delivery and promote transparency in public administration. It also highlights the importance of collaboration between government, civil society, and the private sector in driving positive change. In addition to the digital processing advancements, there has been a significant legal development that further solidifies the protections for ZEP holders. On the 29th of June, 2023, the High Court in Pretoria delivered a landmark ruling that provided substantial legal protections for ZEP holders. This ruling was the culmination of a series of legal challenges and advocacy efforts by various civil society organizations, including the Helen Suzman Foundation and the Consortium for Refugees and Migrants in South Africa, COMSA. The High Court's ruling brought much-needed relief to nearly 180,000 ZEP holders who had been living in a state of uncertainty and fear of deportation. The Court's decision was a direct response to the Department of Home Affairs' November 2021 announcement to terminate the ZEP program, a decision that had been met with widespread criticism and legal challenges. The termination of the ZEP program was seen as a violation of the rights of ZEP holders who had been living and working in South Africa for many years. The Court's ruling was a significant victory for ZEP holders and their advocates. It found that the Department of Home Affairs had acted unlawfully and unconstitutionally in terminating the ZEP program without proper consultation and consideration of the impact on the permit holders. The Court ordered that ZEP holders cannot be arrested, detained, or deported, and that they must be allowed to enter and leave South Africa freely. This ruling effectively nullified the department's decision to terminate the ZEP program and provided a one-year extension for the permits, allowing ZEP holders to remain in South Africa without fear of reprisal. The Court's decision was based on several key legal principles, including the right to fair administrative action and the duty of the government to act in a manner consistent with the Constitution. The Promotion of Administrative Justice Act, PAJA, requires that any administrative decision that materially and adversely affects the rights of the public must be made in a fair and transparent manner. The Court found that the Department of Home Affairs had failed to adhere to these principles by not conducting a proper public participation process before making the decision to terminate the ZEP program. The ruling also underscored the importance of public participation in administrative decision-making. The court noted that the department had shown a notable disdain for the value of public participation by not consulting with ZEP holders and civil society organizations before making the decision. This lack of consultation was seen as a violation of the principles of procedural fairness and transparency, which are essential components of good governance. The impact of the court's ruling extends beyond the immediate relief provided to ZEP holders. It sets a precedent for how the government must handle similar cases in the future, ensuring that the rights of vulnerable groups are protected and that administrative decisions are made in a fair and transparent manner. The ruling also underscores the importance of the judiciary in upholding the rule of law and protecting the rights of individuals against arbitrary and unlawful actions by the government. The response to the court's ruling has been overwhelmingly positive, with various stakeholders praising the decision as a victory for justice and human rights. The Helen Suzman Foundation and COMSA have welcomed the ruling, emphasizing the importance of protecting the rights of ZEP holders and ensuring that they are treated with dignity and respect. The ruling has also been praised by legal experts and human rights advocates, who see it as a reaffirmation of the principles of constitutional democracy and the rule of law. Thanks for watching. Please don't forget to like, share, comment, subscribe, and hit the notification bell for more updates.